If your asylum claim in Ireland is refused, that's not necessarily the final word. There's a second decision that comes after it, one most applicants don't even know to expect. And once it's made, you may have just days to respond. Today I'm walking you through exactly how this works, step by step. Quick setup: you apply for international protection in Ireland, and the International Protection Office, the IPO, decides whether you qualify as a refugee or for subsidiary protection. If they say no, that's not automatically the end of the road. There's a further decision that follows. That's what this video is about. Let's keep this simple. Think of your asylum claim as question 1. Are you personally at risk if you return to your country? If the answer is no, there's a question 2. Permission to remain. Even if you don't meet the legal test for asylum, has your life in Ireland become significant enough that you should be allowed to stay anyway? Here's the part that surprises people. You don't file a new application for this. It's not a fresh form, and it's not re-arguing your asylum case. The Minister for Justice, Home Affairs and Migration looks at the information already in your file, your family circumstances, your personal ties, your situation in Ireland, and can decide based on that. You can also send in extra information at any point if your circumstances change. So when does this second decision actually happen? It's triggered once the IPO recommends that you should not be granted refugee or subsidiary protection status. At that point, under Section 49 of the International Protection Act 2015, the minister must decide whether to grant you permission to remain, based on your file. Here's something genuinely useful to know. The minister can make this decision whether or not you've appealed your asylum refusal to the International Protection Appeals Tribunal, or IPAT. You don't have to wait for your appeal to finish, and you don't have to choose one process over the other. Quick note if you're applying more recently. If you applied for international protection on or after 12 June 2026, you're under Ireland's new International Protection Act 2026, which changes appeal bodies and timelines. The core idea of a separate permission to remain style decision still exists, but this video focuses on the process most current guidance covers, for applications made before that date. If that's your situation, a solicitor can confirm exactly how the new rules apply to you. So what does the minister actually look at? By law, 4 things. 1. Your connection with Ireland. This includes how long you've been here and the ties you've built, though it's broader than just time on the ground. 2. Humanitarian considerations. Health conditions, vulnerability, and personal hardship all fall here. 3. Your character and conduct, both in Ireland and elsewhere, including any criminal convictions. 4. Considerations of the common good, like national security and public order. There's also an overarching test. The minister has to have regard to your family and personal circumstances, and your right to respect for private and family life. That's the legal foundation everything else sits on top of. Sounds fairly straightforward. Here's the problem. This is exactly where strong cases quietly fall apart, and it's almost never for the reason people expect. If permission to remain is granted, you'll get a letter confirming it under Section 49. You register with your local immigration office and receive a stamp 4, meaning you can work in Ireland without a separate employment permit. And here's a detail worth repeating. If you have an appeal pending at IPAT, you're allowed to keep it open. You don't have to withdraw it just because you've been granted permission to remain. If it's refused, and your IPAT appeal is also unsuccessful, you get one more opportunity, a permission to remain review. You'll receive a PTRR form, and you have 5 working days to submit it, along with any new information about your circumstances. This is different from a second deadline that can come later. If your permission to remain review is also refused, you can still apply for assisted voluntary return. But you have to notify the minister in writing within 5 days of that decision. 2 separate 5-day windows, 2 separate purposes, which is exactly the kind of detail that's easy to miss under pressure. Strip away the legal terms for a second. This decision determines whether someone keeps their job, their home, their children's school, their community, the life they've spent years building. That's why getting each step right and not missing a deadline matters as much as it does. Here's how strong cases get lost. Vague, general statements instead of specific detail. "I've built a life here" carries far less weight than "I've lived here 5 years, my daughter is in 3rd class, and I've worked continuously since receiving labor market access." Or no supporting evidence, no proof of tenancy, employment, school enrollment, medical records, or community ties. Missing a deadline, especially the 5 working days to submit a permission to remain review, or the separate 5 days for voluntary return notification. Leaving it too late to involve a solicitor, when there was still time to build a stronger file. If you're going through this, here's what genuinely strengthens your position. 1. Get legal advice as early as possible, ideally before your asylum decision even comes back. You may be entitled to free legal aid. The Irish Refugee Council and the Legal Aid Board can point you toward a solicitor experienced in this exact process. 2. Build your evidence file before you need it. Don't wait for a refusal letter. Useful evidence includes proof of how long you've lived in Ireland, tenancy agreements, utility bills, official correspondence, proof of work or study, labor market access permits, pay slips, school or college enrollment, letters from your children's school, GP or community organizations, medical records for any ongoing health conditions, character references from employers, neighbors, or community groups. 3. Be specific, not general. The stronger applications tell a detailed, evidenced story of your actual life in Ireland, not a broad statement of hardship. 1. Write down every deadline the moment you receive it. Set a reminder immediately. Don't rely on memory, not with a 5-working-day window. 5. Use the International Protection Applicant Portal. If you applied on or after 30 July 2024, check your case status and upload documents there directly, rather than waiting for post. 1. Know you can keep your appeal open. If you're granted permission to remain while your IPAT appeal is still pending, withdrawing it is your choice, not a requirement. Talk it through with your solicitor before deciding either way. If this is the first time you've heard how this second decision actually works, you're exactly who this channel is for. Subscribe. I turn processes like this into plain English before a missed deadline costs you something. Here's what most people don't realize. Even a permission to remain refusal isn't necessarily the final chapter. Assisted voluntary return remains an option on your own terms, and in genuinely changed circumstances, there can be routes to have a case looked at again. This process has more steps than most people are told about, which is exactly why preparation, not panic, is what protects you. None of this is meant to frighten you. It's meant to make sure you're never caught off guard by a deadline you didn't know existed. Permission to remain is a real, meaningful opportunity. Understanding exactly how it works and preparing properly is the single biggest advantage you can give yourself. I've put together a free 1-page checklist covering every document and deadline in this process. Comment list, and I will send it. Subscribe so you're never the person finding out about a 5-working-day deadline on day 4.